Welcome to the Law Awareness Weeks at CDC 2024. This webinar is part of Law Awareness Weeks at CDC 2024. It is a collaboration between Pro Bono SG, the 5 Community Development Councils, National University of Singapore, Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, the Singapore Corporate Counsel Association Pro Bono Chapter, and the Singapore Association of Social Workers, supported by People's Association. I am Regana, and I'm your webinar. I'm not your webinar, I'm your host. Today's webinar is Navigating the Employment Landscape. First, some housekeeping matters. We will be using Pigeonhole Live for the Q&A. You can submit your questions at any point during the webinar and also vote up any questions you feel very strongly about. If you have a smartphone or a tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Next, key in the event passcode, which is LAW, L-A-W, CDC 2413. I'll repeat that. Law CDC let me do this again. LAW CDC 2413 as shown on the slide. Alternatively, you can click on the link shared in the chat function to launch the Pigeonhole Live on your device. If you're viewing the webinar from your desktop or laptop, you should receive an invitation to launch Pigeonhole. Now, today's discussion is not intended to substitute any professional legal advice. If you require legal advice, please consult a lawyer. So with that, I'd like to introduce you to our 2 panelists for today's webinar, Amarjit Kaur and Patrick Tay. Now, Amarjit is the head of employment at Withers Carter Wong Singapore. She is consistently recognized as the leading lawyer in the area of labor and employment across global legal directories. Amarjit is an advocate for gender equality that I know and leads the global DEI group at Withers. Patrick, hi Patrick, is the Assistant Secretary General of NTUC and the Director of NTUC's Legal Services and Strategy Division. He is also a member of Parliament representing Pioneer SMC since 2020. Now, Patrick is a familiar face and always has been in the forefront of policy making in Singapore, particularly around employment practices and governance. Thank you both for joining us for today's webinar. Very interesting and very important things to talk about. Now, the employment law continues to evolve so rapidly. Even when I was reading it, I was like, and staying informed has become essential for both employers and employees. Yes. So imagine everyone, a workplace where everyone is equipped with a fair, a balanced environment. So today we will dive into some of the most recent amendments, updates that are reshaping this landscape in Singapore. And it's so vibrant, from the tripartite guidelines on flexible work arrangements, which will mandate FWA requests from December, which is quite close. The upcoming platform workers bill designed to offer greater protection in the gig economy, and how our government is taking active steps to address the need of diversity in the workplace. So important. So our 2 experts here today is going to unpack all these developments. Now, Amarjit will provide the legal perspective on these changes, and Patrick from the NTUC side will share insights on what's happening on the ground, how this shifts will affect both employers and employees across the sectors. We will cover FWA guidelines, platform workers bill, enhanced leave provisions, and upskilling, reshaping the workforce. So let's begin this journey. So Amarjit, I'm going to hand over to you to walk us through what's happening in this landscape.
Thank you, Regana. Firstly, thanks for the introduction and for setting the stage, because I think you're absolutely right. We are in an era of tremendous, development in the employment landscape. I don't think we've seen so much movement in many years as we have seen in maybe the last 1 to 2 years. So this is very, very heartening because, as you say, we are seeing a shift towards greater employee protection. And that cuts across all the things we're going to talk about today, because all of them are geared towards a fairer, safer, more inclusive workspace. And I think that's really heading in the right direction. As you say, this is of great interest to both employers and employees. And as we know, employment is deeply personal to us as employees in our own right. So I think this should make for an exciting discussion. So let me go through some of the key headline changes. The first is what Rogana has spoken about, which is the workplace fairness legislation. Then we have the tripartite guidelines on flexible work arrangement, increase in family leave policies, new temporary financial support scheme for those who are involuntarily put out of employment. And also we've got something on draft guidelines on workplace mental health, but I think that one we are parking for now. So let's just go into some of the topics. Let's talk about workplace fairness legislation in the first instance. Hang on. Oh, we're starting with flexible work arrangements, pardon me. Okay, so this is something that everyone is very interested in.
Very excited.
Must employers grant it? You know, if we want to work flexibly, do the employers now have to give it to us? I think this is the million-dollar question, because we are now at crossroads. Because if you read the press, if you read the news, we have some very big names saying we are rolling out a return to office policy, RTOs, right? That's a new buzzword. RTOs means going back to office almost full-time, 5 days a week. And it's not just in the overseas news, we're also seeing it locally. At the same time, government and the tripartite partners, of which Patrick is a very, very big part, have rolled out these guidelines, which take effect on 1st December 2024, which is, less than a month away. So how do you reconcile between RTO mandates and flexible work arrangements? And I think that's really the million-dollar question at the front of everyone's mind. Okay, so let's go into this. FWA guidelines come into force very shortly. Who do the guidelines apply to? They apply to all companies regardless of size. So when we go to the workplace fairness legislation, you will see that applies to companies with more than 25 employees, because there's a large administrative burden. So they are being relieved of it initially, with the matter to be revisited in 5 years. However, FWA guidelines apply to all, including the SMEs. So this should be, considered by everyone as something that is relevant to them, the employers. And employees and SMEs should also be aware of this, because they stand to benefit from this too. Now, which employees are entitled to make formal FWA requests? Employees who are not on probation or who have completed their probation. Now, employers can still grant or allow employees on probation to make formal FWA requests, but that's at their discretion. Okay, so that's something for them to think about if it suits them, or they can consider it on a case-by-case basis. Now, what are the FWA guidelines? Are they law? Because companies ask us, is this law, does it make it mandatory for us? Firstly, it's not a law. It's a guideline which the tripartite partners have worked very hard to come up with, but they fall short of the law. So we call them strongly persuasive, and companies should adopt. Okay, because if they don't, they may face sanctions. MOM, TAFEP may issue warnings, corrective orders, and in worst case scenarios, if they really have other infractions, this may add to that. And as we know, the worst thing that can happen in Singapore is curtailment of work pass privileges. So, at a holistic level, if this is taken into account as well, that they have a bad record on FWAs, I think that could lend some weight to the decision-making process. Okay, now what do these guidelines do? They set out processes for employers on how they should be dealing with such requests. They basically provide a formal avenue for employees to request. Employers must consider fairly, must get back to the employees within 2 months in writing with reasons. For example, if you reject it, you can't just say no. You can't spend 2 months and just say no. You have to provide reasoning. So what is very interesting is that the guidelines don't prescribe reasons. They don't say, hey, here are the reasons you can give that are reasonable business grounds. They have to be based on reasonable business grounds, okay? Cannot just be reasons like we do not support, the firm has never supported flexible working. Therefore, the answer is no. It has to be linked to certain things, which I will go through, which are usually cost, practicality, and productivity, okay? Now, a lot of people have informal arrangements in place. This is a formal process. So the informal arrangements can continue in place. This is just providing an avenue so that those who, for example, would hesitate in a work environment that's not conducive will now have a means to request, and the employers will now have to consider. I think that's really the best part of this, which is it helps bridge the gap for those companies that are not evolved enough to, for example, offer such arrangements on an informal basis. Now, why have the tripartite partners come up with the FWA guidelines? One of the key factors is that Singapore's strongest resource is our manpower. And we have a lot of latent talent in the workforce. So mothers, caregivers, elderly who are professionals who have retired or who are, for whatever reason, not currently active in the workforce. The flexibility in FWA is intended to account for the needs and the requirements of people who maybe cannot work traditional work hours. So this gives them an avenue to be productive and be part of the workforce, whereas they may otherwise not have the opportunity in a traditional 9 to 5 work environment. The second is that we also are a nation that's trying to get people to have families, right? We are trying to support, people having kids. And I think this is a very critical part of it because we know that parenthood and particularly motherhood comes with a penalty, right? There's a motherhood penalty. So these kind of things equalize the playing field a little. And the third is to help businesses maintain a competitive edge by having a workforce that is, a little less traditional, but maybe more suited to what they need. Okay, so this is what do employers have to do? They have to implement processes to fairly consider FWA requests. Now, employers should not take this as a tick box exercise. I think this is something they should really consider carefully because there's a business case for this, right? Not just that they will get in trouble if they don't, but there's a business case for having a productive workforce. And people are more productive when they're happy, yeah? So, if you consider their life circumstances and you don't force them into a 9 to 5, you give them a late start, you give them some shift work, some job sharing, I think it makes a huge difference. And I say this from personal experience, actually. When I had my kids, they were born in London, and I actually did job sharing in the local government council. And I actually went in there and I said, look, I can do this in a shorter amount of time. Let me do this. And they allowed it. And that allowed me to participate in the workforce at a time when I needed it the most. And I think that's why I'm here today. So I'm a huge proponent for this. Do this for the right reasons, right? Now, it's not mandatory for employers to grant every FWA request, not mandatory. Employers continue to maintain the discretion. And I think that's important because it's a balancing act. Otherwise, you will have a workforce that all works from home, all works certain hours. You will have an imbalanced workforce. So employers still maintain the discretion and the prerogative to decide. But they should exercise the discretion wisely and fairly. I think that's really the message. Now, if we go into the next slide, which is examples of reasonable grounds. So some of the examples are productivity, output, ability to offer certain services which would be impacted if certain requests are entertained, lack of feasibility, certain jobs do not lend themselves, for example, to remote work, a client-facing role at a bank, etc. Manufacturing where you have to be hands-on. But again, there are other avenues of flexibility, right? It's not just place, it's time and it's load. So I think all those can be considered. Increase in business costs for employer. I think this is one that will be used quite readily by employers, but I think they should consider this from a long-term perspective of how this is going to impact them in the long term rather than just short-term thinking on this. Examples of unreasonable grounds. We don't support it because we've never done it. We want to see you to believe you're doing work. So we need to see you in the office. We have clients who, struggle with this because they feel that the lack of trust doesn't help in the relationship. And also, I think the worry of floodgates. So if we allow your request, we have to allow everybody's request. I don't think that's the case. Again, case by case basis, you should consider each case fairly without worrying unnecessarily because there's still lots of people who love going to the office. So I would say, that should temper any fears about floodgates. Now, permutations of FWAs, this is important. When we think flexibility, it's usually we think, work from home.
Yeah.
But that's not it. It's more than that. Work from home, work elsewhere. It's flexi time. So, for people who have to pick up their kids early from childcare, let them leave a little early. Let them start a little early. Staggered working hours, flexi hours. compressed work schedule. So they work shorter days but longer.
Yes.
Less number of days but longer days. For example, if that suits them. Flexi load is job sharing,
Yeah.
part-time work. I
Having a
think
share.
yes, all of that's very helpful because again, it allows you to contribute within your circumstances, right? So I think employers should be alive, even if they're going to reject a request. Let's say somebody says, I want to work from, but their job scope doesn't lend itself easily to remote working.
Mm.
Employers should say, let's discuss alternatives. What's the concern? Why do you need to be home? Maybe you need to be home during certain critical hours.
Yeah.
We can discuss hours of work. So it's about dealing with those kinds of things.
So actually, Amaju actually brought up a very, very good point. I think there's a bit of a misunderstanding and miscommunication when we talk about flexible work arrangements. Remember, it's not work from home or work from anywhere. But more importantly, the flexi time, flexi load, flexi place. So I thought that's very, very important. And that's key to the flexible work arrangements. And I think before the guidelines came into force or is coming to force, we already had actually a tripartite advisory and even standards as well. So very, very important. I thought to clear the air on this, particularly for employees who may be going for this, as well as employers who are coming up with policies or even have existing policies and reviewing some of your guidelines, is to take note of, flexible work arrangements are actually flexi load, flexi place, and flexi time. So not just work from home. So I think people tend to equate that. So I remember when this guidelines were like fleshed out a couple of months ago, there was a big headline that says Singapore goes on 4-day work week, and then and then some says you can go work from home permanently. So I thought there was a bit of a misunderstanding of the essence of or the spirit of FWA. So this is to clear the air on this. In fact, Amaj is right, because I think these days not just looking after kids and caregiving, actually caregiving has taken a new spin. In fact, the labour movement has been engaging many workers and employees in the past couple of years, and something that came up interestingly quite a lot is caregiving arrangement. Because many of us are born during the baby boomer generation when we had like only 1 or 2 siblings, and then now we have our own set of parents who are living very long, easily more to 100 years old, and we also have young children at the same time, and then we have our in-laws as well. For those who are married, so you already have 2 sets of parents and your kids. So actually, caregiving arrangements can take a toll quite a bit. I know because I send my mum for her medical appointments, and it's almost half a day. Yeah, just to queue up and get the medication and seek consultation and do the relevant checks. So you can imagine flexible work arrangements and this flexi time, flexi load, flexi place is going to add a new dimension and basically gets people more engaged, the workforce more engaged, more productive, and in Singapore, unfortunately, we have a very low fertility rate. Now it's gone below 1. Very sad, very dismal, and really literally every worker matters, and so therefore everyone will try to enhance the labor force participation rate of women, those who have caregiving arrangements, as well as we have an aging population. So we hope, whether in a small way, a big way, job sharing, flexi time, flexi place, we try to maximize everyone who is keen and able to work and want to work to be able to be engaged in the workforce.
Absolutely. I think that's brilliant.
Actually have some questions
Sure.
coming in from our participants. Now, I think you did say that the FWA will apply to everyone. So this question is, does it apply to civil servants?
Leave that to Patrick.
Me, but anyway, I think FWAs are already practiced by many organizations in the company industry, including the public sector.
That's right.
Of course, Employment Act does not cover government employees, but they have the government instruction manual. I remember because many years ago, decades ago, I was in the civil service. We had to take exams on the government instruction manual, and it actually fleshed out, including the public service PSD circulars and minutes. Actually set out some key guidelines on flexible work arrangements. So actually, in to a large extent, it's also relevant to them as well. So flexible work arrangements, I think government has to put the money where the mouth is.
I agree.
Proposing this, and I so therefore should be in fact ahead of the curve of this.
Oh, sure.
Yeah, but more importantly, please recognize, besides the 3 flags I talked about earlier, is the fact that it's quite situational. There's no one size fits all. That's why it's we set it out as a tripartite guidelines as a start, because it's different folks or different strokes or different folks, as well as whether it's what industry, whether you're a frontline worker, whether it's operational needs. So all this will determine. So there's no one size fits all. You probably need, through these guidelines, I hope, more open and transparent communication two-way from the employer to the employee, as well as the employee to the employer, so that we have a more engaged workforce and then have a good conversation on this. And for those who already, I know big multinational companies have already good practices on this. Do not fret. If you already have practices and nice, extensive, comprehensive guidelines, just stay that way. Stay that way. Don't fret. In fact, TAFEP actually came out a 22-page report or guideline. We'll probably give the link later. And those are for companies that maybe perhaps micro SME startups or SMEs who have not had the full benefit of having proper guidelines. They can actually pick a leaf from there and replicate that and then formalize the process. Because if you look at this stack of tripartite guidelines, it actually applies to specifically sort of like formal request. So there's already informal fine, but it's basically to cover only formal FWA requests. So this nice booklet will give you some resource to cut and paste and to take to pick a leaf from, so that you don't lose sleep over this upcoming guidelines, which will happen in a couple of weeks' time.
Okay.
No, I'm picking up from Patrick, right? I think this is absolutely critical, right? Employers must implement proper policies because they can't go into this without policies in place. They need a form, right? The form is readily available, so you can pick that up as a template. More importantly, they need to think about how they're going to be handling such requests consistently. Internally, what processes are they going to put in place for managers, for example? What trainings are they going to put in place? Because some managers, different people handle things differently. And you may need to set the tone from the top to say, look, this is how we're going to do it. We have a decision tree. This is what happens. These are factors you can consider. These are reasons. For these jobs, it may be not so suitable to do this, but here are the alternatives, so that the managers are equipped to have meaningful discussions. So I would say, please make the effort to put in place good policies, including grievance policies, okay?
That's right.
So I have a question. Now that with the FWA coming into place, further down the road, employers, would they have to work in like a clause into contracts?
On this, on FWA?
Yeah.
So I can tell you that recruiters, all the recruiters I've spoken to, whether there's a clause or not, one of the first questions employees ask is, got flexible work or not? What kind of flexibility do you offer? And this is for legal roles as well, which and associates jobs are generally, known to be all hours, right? So forget the 9 to 5.
Same feedback for the rest of the workforce.
Right.
I think increasingly we're hearing from employers that more of the new hires, as well as those people coming for interviews, are asking, when the usual question, any other questions for us?
Yeah.
Yeah, they will say, do you have flexible work arrangement policies?
Yes,
Yeah.
yes.
So I think
It's
that's
a norm now.
that's
Yes.
popping up quite a bit. Yeah.
So, and I think that will distinguish the more evolved employers from the others. So in the war for talent, I think having policies that say, we support flexible work will set them apart.
Okay. Maybe just take one more question on the FWA guidelines. Someone's asking about, will it also apply to foreign work pass holders, such as EPs, people on employment pass and SPs pass?
Yeah, I said it's a tripartite guideline, so it should apply to all workplaces. So regardless of local or foreign, I think essentially this is a set of tripartite guidelines agreed by the government, in this case, Ministry of Manpower, as well as the Singapore National Employers Federation and the National Trades Union Congress. So you apply to all organizations, regardless of whether the employee is local or foreign. Unless, of course, like I said, I alluded to earlier, you need to see the substance of the role.
Yes.
Some frontline roles, can you ask a bus driver to work from home? Obviously not.
Yeah.
Yeah. I learned this from during the pandemic, where we had to give some concessions to frontline essential service workers, which is about a quarter of them. So these roles, unfortunately, you can't bring the whole machine back home to operate it, right? Unless you do it remotely. So some things can be done, some things can't be done. So I think the key thing is to there's no one size fits all. I just had to reiterate this again, and it's probably going to be a case by case basis to see the needs, and of course what the company can accommodate, and of course not compromising things like, I know increasingly employers are quite worried about teamwork, camaraderie, company culture, and whether a complete flex and complete work from home will dissipate that. So I think increasingly this is the conversations that are going around, but I think we need to strike a right balance. the key is to strike the right balance. There's really no one size fits all. So it's how to in the course of implementing FWA, use that as an opportunity to engage your workers and your workforce and your employees and have some meaningful communication, and at the same time also understand them and what's happening in their social and family life better.
So to summarize that, it's not only work from home.
Yeah.
There are many ways
Permutations. Yeah.
and permutations that what FWA can offer to both employers and employees. And I think it's about having that conversation,
Yeah.
right? Okay, Amajit, what's next? What are
Okay.
we going to unpack?
So I think we've done a good job summarizing the flexible work arrangements guidelines. We have Patrick here who shared some great insights. Let's move to workplace fairness legislation.
Maybe before we go into the workplace fairness
Yes.
legislation, I mean, earlier on I talked about some resources, so I'll get the Pro Bono SG team to pump in some of the links, or if convenient later on. I mean, I alluded to the guide and a few other resources. Actually, so don't fret, employers and employees out there, don't fret. There are quite a nice compendium of resources for you to tap on and make use and to implement it. Don't worry, although it's just 3 weeks away, it's quite easy reading and should be quite easily done in case you need to get something up and going fast and hearing this for the very first time. Yeah.
Okay, I have one thing to add, okay?
Yeah.
Before we jump to the next one, I want to say, so Patrick forgot to do a plug for if any disputes come to NTUC and TAFED.
Right.
I want to say that the main thrust should be trying to resolve this internally,
Yes, of
right?
course.
Because we are working towards harmonious workplaces. Any issues, that's why you need a grievance process. And then the companies need to know what to do if people do raise a grievance. Do you have an appeal
Yeah.
process? How do you consider? What can you do? So they need to really think about this, okay? That's all I want to say.
So
Okay.
then, quick question for employers. You say it's not mandatory, but it's good to have because eventually it's going to get there. Is there a hard stop that they must implement this?
My personal tip, having seen what's happening in
Yes.
the labor relations, industrial relations front is please have it. Why? Because increasingly, I mean, Amajit will be fully aware, even our state courts are giving a bit more weight to tripartite guidelines.
Yes.
and ruling in I remember 2 recent cases and alluding to the tripartite guidelines, maybe not the flexible work arrangement ones, but other tripartite guidelines, to say that you'll be not so consistent to if they were to rule counter to the flexible, I mean the tripartite guidelines. So
Yes.
tripartite guidelines has come up with added persuasive authority, a more weighted persuasive authority these days, over and above the Industrial Arbitration Court, which has all along been following tripartite guidelines, including if the matter goes to conciliation and Ministry of Manpower. Ministry of Manpower will also take reference from the tripartite guidelines. So increasingly, and even our legislation, for example, like the Employment Claims Act, particular section in there actually even cross references to the tripartite guidelines. So I think increasingly there's a more weight given to tripartite guidelines, especially for those of you who operate in Singapore. And this was quite unique. This tripartite guidelines, tripartite advisory standards are unique to Singapore, really unique to Singapore. So therefore, pay a bit of attention to those so that you don't run foul of and then don't get into trouble, with the relevant agencies.
Agreed?
Shall we unpack the next
Yes.
update?
Yes. So the next big one, workplace fairness legislation. Patrick, first question is, when will workplace fairness legislation come into force? So maybe I let you start with that update.
Yeah, I wanted to crack a joke before that. Because but you see the slides, you see it was like a bracket WFL. It's not work from lobby. Yeah, because I mean, everybody getting used to the
in Bali.
Bali, London.
Yeah. But yes, this piece of legislation, I mean, announced 3 years ago, and I remember the then Prime Minister Lee Hsien Loong announced this that they're doing a national rally that we're coming up with some form of a workplace fairness legislation. So it's almost coming to 3 years in the making, and yes, it's going to be ready. And I'm made aware that next week, likely the first reading of the introduction of the Workplace Fairness Bill will be out next week. So look out for it. My only caveat is that it's quite a comprehensive and quite a interesting, eclectic piece of legislation. Why? Because I think that a lot of work has gone into it, a lot of consultation with lawyers, in-house counsels, and really scouring the whole globe, in looking at the different anti-discrimination legislations from the Equal Opportunities Act in the US, to the UK anti-discrimination stuff, and as well as in Australia, and I think we are trying to put something that's in place and also align with some of the tripartite principles and the existing mechanisms, whether it's the Employment Claims Tribunal or the Tripartite Alliance for Dispute Management, or some of these tripartite way of resolving some of these issues. So it's an interesting piece. I'm looking out for it next week when it gets introduced in Parliament.
So my curiosity is piqued when you say eclectic.
Yeah, I was going to ask how
I
thick
can't
is
wait
it?
to, yeah, firstly, I can't wait to read it. And secondly, I don't know what, what will be in there. But the one thing I have to say is I think this is a very welcome piece of legislation, very much overdue, because as lawyers would know, it's been very hard to make claims on behalf of employees when you don't have a cause of action.
Mm.
So we've had to try and shoehorn it into, responsibility to provide a safe workplace for bullying or harassment or whatever. And it's very hard, and discrimination, it's very hard. So this is very much welcome. Why is it being enacted? For precisely that reason, which is to strengthen protections against workplace discrimination, harassment, unfair practices at work, including hiring, firing, etc. So this covers the whole life cycle.
And anyway, this
Yeah.
is not exactly new, because we already had the tripartite guidelines on fair and progressive
That's right.
practices, and this is public information. I think the last 3 to 4 years, every year TAFEP sees about a couple of hundred complaints on discrimination. So Amajit will share more on some of the protected characteristics, but essentially the two things that came out quite a bit, comprising the bulk of the complaints, most 80% of them the last couple of years were in the area of age and nationality. So like Majid rightly pointed out, I think we are in Singapore, we are very cosmopolitan. We have a 1/3, 2/3 rule, where we have 1/3 foreign workforce and local workforce, 2/3, and we have an aging population. And now we also want we also quite big on DEI and
Yes.
and wanting to be more inclusive, and coupled with the fact that we have a multiracial, multi-religious a country and society. So I think we are doing this in a very, very preemptive manner. I never expected this will happen so soon, but I'm glad it has come to fruition, and I hope that you'll be a piece where you will help make the whole workplace, work environment a fairer and a more progressive one. Yeah.
I agree. I think this is at the heart of our social fabric at work. Because as you say, there are so many differences. But ultimately, we want to be able to work together despite the differences.
Because we spend a lot of time
We
at
spend
work.
a lot of time. Yeah, most of our waking
10
hours are at work,
Yes.
right? So I think this is absolutely critical. And as Patrick says, there are lots of complaints. But the good thing is that the statistics point towards decreasing numbers of complaints about discrimination or concerns about discrimination. So the polls have shown that the numbers are dropping. But what is of concern is 7 out of 10 do not report.
That's
Do not
right.
report. Because again, discrimination, it's insidious sometimes. You feel it.
Yes.
But how do you prove it? You feel it. How do you give evidence that I'm being discriminated against? So I think the hope is that the WFL, not Work from Lobby Workplace Fairness legislation, will help people with a framework for what can be done, cannot be done, right? And protected characteristics is at the heart of this. So I've already covered, right? Who does it apply to? Employers with more than 25 employees. So that's important. So the smaller ones don't have the administrative burden, but this will be reviewed in 5 years. And I think we can bet our bottom dollar it will be rolled out to everyone by then. Am I right, Patrick?
I hope so.
Crystal
In
ball.
fact, I was the one that one of those that said, why must we have this 25 employee? But I think that we recognize that there are some startups, some micro SMEs, which are maybe even other guidelines and other practices, they may not have the capacity. So we're giving them some breathing space. But remember, yes, breathing space, but employees, if need to, can still raise it to TAFEP and the necessary dispute resolution mechanisms to resolve some of these. Yeah, because like I said, our key principle, just like in many of our labor legislation, is try to resolve things at the lowest level, and and as in even in our legal system, try to adopt alternative dispute resolution. Yeah.
Don't burden the courts, in other words. Okay, now what does WFL make? What does it say that employers must do? What is mandatory, right? Firstly, is prohibit workplace discrimination based on protected characteristics. Okay. What is discrimination? Firstly, I think it's wonderful that there's a definition. Discrimination is defined as making an adverse employment decision based on any of these protected characteristics, which are nationality, age, which is the most prevalent form of discrimination, race, religion, language, sex, marital status, pregnancy status, caregiving responsibilities, and disability, mental health conditions. I have to say, I was most happy to see some of these, which I was not expecting actually. So,
Yeah.
a pleasant surprise: caregiving responsibilities, disabilities, mental health conditions. I think very, very important that we recognize that these should be protected characteristics.
Yeah.
Now, employers should take note that the obligation to prevent discrimination covers the whole life cycle.
Yes.
So it's not just at a particular point, it's from hiring
Yeah.
to firing and
Yeah.
everything in between. So they need to be mindful of this throughout and in all decision-making processes and stages. So what should they do, right? Prohibit retaliation, which is absolutely critical, right? Because one of the biggest cooling effects on reporting is that I'm scared I will lose my job. I'm scared I will be overlooked for promotion. I may be demoted. I may be punished in some other ways. And these things do happen. We see in
That's right.
practice that, when people do whistleblow or there is concerns, they are very often actually retaliated against. I had a particular case where somebody actually filed a complaint for bullying and for discrimination because she felt very isolated because of, in her case, nationality and race. And this was a fairly large MNC, and within a week she was terminated for taking too many things from the technology vending machine. And there's no policy on a limit to the number of things that could be taken from the machine. So it just came out of nowhere. So it sort of became self-fulfilling for her because she kept saying, will they retaliate? And they shouldn't, because they have a non-retaliation policy. So again, it's not just putting in place policies, saying we don't retaliate. It's about tone from the top, we don't retaliate. And living it, talking, walking the talk, not just.
So in a way, this provision on prohibiting retaliation is a very first semblance of whistleblowing legislation.
That's right. In its infancy, I think
yeah.
this is really it, which is absolutely critical. Otherwise, it doesn't work.
Yeah, because like you said, there may be every one case, there may be 3 other cases that
Don't report.
Don't report.
Yeah, for these very real reasons, right? They have to protect their rice bowl. They have kids to feed. They have responsibilities. So people would rather put up with it, A, or B, they leave. And you don't want that. You don't want a workforce that has to leave because they don't feel empowered to raise complaints. So grievance reporting processes have to be tagged with non-retaliation policies, right? And I think that's not going far enough. So I actually think the policy should start with anti-discrimination, non-bullying, so anti-bullying, anti-harassment, including sexual harassment. So that's a very big part of it, right? And then you get to grievance. From grievance, you then have investigation policies and procedures. And you, at the back of that, have disciplinary policies, because this whole set of policies work cohesively together. Sorry, Ragana, you're going to say something.
Yeah, it sounds a lot, from if I was an employer, I'll be
Yeah.
a bit nervous right now because I've got to put in all of this in place, right? So are there any best practices that you can sort of share? I mean, Patrick or, Majid, for the
maybe
employers
just
out
a
there?
quick so I just want to reassure our employers and some of you out there who maybe in the HR function having to take the full brunt of this. We already have the tripartite guidelines on fair and progressive employment practices. So much of this takes a lead from that. And that piece of tripartite guidelines will continue to be enforced because the protected characteristics do not cover all comprehensively every single, it's not exhaustive. So therefore, those that are not covered in this main piece of legislation can still have recourse to the TGFEP, Tripartite Guidelines on Fair and Progressive Employment Practices. So that's one. And if you need to take reference to some material, that would be one go-to place. If you take that piece of traffic guidelines and implement some of the things that are listed there, I think you'll be fairly secure and safe. The other one is, of course, we actually published I was part of the tripartite committee on workplace fairness, and we published a deck of recommendations. So I'll probably get the Pro Bono SG team to flesh out the links, as well as maybe send to all of you later on the link to this nice pack of recommendations, quite a number of them, slightly more than 20. But it gives you a guide to what to look out for. But anyway, hang in there. The first iteration of the bill will be introduced next week, I think. And you should be able to digest that. But I'm actually lobbying that the Shopify Partners work together to come out with some more simpler guide. And maybe that calls for some pocket series
some
or
baseline.
Yes, and
kind of
templates are
structure.
helpful, right? Even
Yes.
if you do a, simple template covering these things so that we encourage adoption, I think that's very important.
Yeah, I'm sure I think as part of the communication process and I think there'll be some window before the full works of the workplace fairness bill or act come into force. So I think that the period of time will be where the actual details, the mechanisms. I'm eager to find out too, because this involves rules of court and judicial mechanisms as well as existing employment claims mechanisms. Yeah.
So this is fascinating. I have one more thing to add,
Yeah,
okay?
please do.
So in addition to all of that, one critical piece of this is that whistleblowers' identity must be kept confidential. So that goes to your point, Patrick. This is almost like an early stage whistleblower protection coverage, because it's absolutely critical. Again, one reason why people don't complain is because, Singaporeans, we are very sort of face conscious. We don't want rumors around. She complained this, that, and then they don't want to be spoken about. So this whistleblower protection protection of their identity is critical.
So if an employer does not or fails to check all these boxes, what are the legal repercussions or consequences they will face? Amajit, I'm going to ask you this question because
Okay.
you have seen both sides.
Yes.
Hmm?
What legal repercussions are? So legal repercussions, Kelvin, can we jump to a slide which is what are the consequences of non-compliance with WFL? Legal consequences across a spectrum. So low severity will be corrective orders issued by MOM. Okay, reviewing their hiring processes, firing processes, everything in the middle. Having employers, superiors attend corrective workshops. Okay. Moderate severity is administrative penalties. High severity is civil action taken by MOM. MOM may also curtail work pass privileges critically and publish, so name and shame, publish the name of the egregious employers.
So not to worry. I mean,
How reassuring Patrick is.
Yeah, I just want to, just a quick answer is wait for the bill to come out, because I think we are still speculative at this nature, because it was some of these guidance points from the recommendations, but the full works, including the penal sanctions and all the.
Very keen to see what
Yes,
comes
yes,
next
will
week,
be
actually,
out
Patrick.
next
Yes.
week, and I'm sure the media or even Ministry of Manpower will come out with a nice infographic so that you can get a quick scan of what's in store in this upcoming piece. Yeah.
Okay, so the next one, and I think one of the most interesting one that has put us in the forefront is actually the platform workers bill. And Patrick, I'm going to ask you a few questions, but the platform workers play an essential role in our gig economy, right? Food delivery, all the aunties and uncles in the PMD coming to deliver our food, our groceries. And this new bill aims to secure a fairer working condition for them.
Yeah.
So Patrick, tell us more about this bill.
Yeah. Thanks Rugana for this. I kind of like starting off on our discussion on platform workers bill or act. Essentially, actually, you look at our Singapore's workforce profile. In fact, we started this journey more than a decade ago, looking at freelancers and self-employed persons. If you look at our workforce profile, about 8 to 10% belong to this category called the freelance or self-employed. You probably can't get these stats anywhere, because if you go to the labor market report by Ministry of Manpower, it says there's this term they use, own account workers. So if you look at that, that's the number of freelance and self-employed that we have in Singapore. So it has been hovering around 180 to 200,000 for the longest. I mean, I watched that quite closely, and increasingly, we also notice that freelance and self-employed workers are from an entire spectrum. Yeah, from your very, very, very white collar to the very, very blue collar, and I think the last 5 to 7 years, with the advent of private hire vehicles, as well as food delivery, as well as a lot of particularly during pandemic, food delivery, as well as delivery services for packages, etc., has taken a new spin and new forefront of our economy, and now it forms quite a bedrock for many of us. And as we, as the size of these three segments, from the private hire vehicle, taxi operators, including the food delivery as well as the other deliveries, we realized that they face attendant issues in the course of their work or in course of doing their freelance work. So that's where it all started. Then we started forming associations for them, the National Private Hire Vehicle Association. Then we have the National Delivery Champions Association, and to cover the food delivery and the delivery services. So then we realized as we consult and speak to them, many of these workers are generally not your median high income earners, generally the lower wage and sort of sometimes hand to mouth, living by the day, because they don't have, for example, CPF contributions from employers. And if they get into trouble and they fall ill, they are already left on their own devices. And more importantly, because of the freelance and self-employed status, we can't avail them union representation. So even a lot of things that we want to do for our traditional workers, because under the Trade Unions Act, it only covers those who are in an employment relationship, and these are not in an employment relationship. So that's how it all started. We started lobbying that, well, why don't we have a sort of like a specific legislation focusing on freelancers and self-employed. We have a particular focus on platform workers because they are the most vulnerable. Having seen what's happened in the pandemic and having seen the various issues from workplace accidents to health and injury, even to non-payment, late payment, no payment, a whole suite of issues. So that's where it all started, and the labor movement started lobbying for some form of dedicated support and legislation for them, to allow them to be represented, and of course to allow them to cover some basic rudimentary rights. So here we are, just passed in Parliament slightly more than a month ago, called the Platform Workers Bill. I think I'm quite elated to share that we are one of the first few countries in the world to have a dedicated piece of legislation for platform workers. Again, really watershed and landmark in more ways than one. I mean, I'm getting a lot of requests from other jurisdictions on, can you advise us how do you all do it? How do you address some of these challenges and issues? Not easy, but I think the fact that there was very close support between the platform companies, Ministry of Manpower, employers, as well as the labor movement, working very closely to dissect some of the issues, what the pain points are, and coming up with this three-piece meal. So if I may just steal the thunder from Amajit a bit, the three-piece meal will be of this Platform Workers Act, or bill, now it's awaiting President's assent, will be three key areas. Firstly, union representation, which traditionally is not availed to freelancers. Secondly, it comes with, besides the bill, it comes with a lot of other policy interventions, like for retirement adequacy, some form of CPF contributions, and government has decided to pick the tab for some parts of it for the next couple of years. And finally, work injury compensation, traditionally availed only to employees or those in employment relationship. We have seen on social media, mainstream media, many deaths, many near misses, many disabilities caused because of some of these riders, delivery, whether it's a mobile mobility device or e-bike, or even walking to deliver stuff, get involved in accident, so they're not covered. So these are the three key areas that with our focus in this new Platform Workers Act.
I think all I have to say is we should be very proud that we are at the front line of these. I think this is just, as you say, it's watershed, right? We are trailblazing because it's recognizing them as a category of their own, somewhere on the spectrum between self-employed and employees. So they may not get all the rights of employees, but I think the fundamental critical rights are being extended to them, and they are the most vulnerable. So it's wonderful that we have done this. And I guess, Patrick, as you say, you're getting lots of calls from overseas, because I think there have been attempts elsewhere, but
yes,
they've not actually succeeded. So
yeah.
Congratulations, Patrick.
Yeah. And then you see some jurisdictions trying to come out with some industry framework agreements with some of the delivery and ride-hailing services. There are also jurisdictions that try in some way to interpret some of the existing legislation to come out with new classification of workers. I mean, we have seen that in the likes of some of the decisions across the globe. So every country is trying to like fiddle their way through and figure it out. and I'm glad we have taken this bold step. I know kudos to the work group and the team for working hard on this. Not an easy piece, because there's no 10-year series to fall back on,
Yes.
and you're literally coming out on your own, very, very unique piece of legislation. Yeah.
And again, a question, what can employers do to prepare themselves for this bill? You know, what are the steps they can take?
Yeah, if I may share a bit, I think as part of the consultation or discussion process as we promulgated this bill and the key recommendations, I think there's a lot of engagement with the existing platform operators as well. So I think they are fully aware of what's coming up. They're fully aware of some of their obligations. So I'm glad that they were part of that process, the consultation, the discussion, the negotiations, as we promulgated this bill, and therefore they are fully aware of what to look out for. I repeat again, it's not for all freelancers. I think we have particularly focused on platform workers because we found that they are the most vulnerable amongst all the whole suite of freelance workers. And we decided to focus on this group because of the attendant issues, as I shared earlier. And I'm glad the platform companies are on board on this. They are fully aware. They are seeing how best to adjust and to for the systems to be able to accommodate to this. And for platform workers, look out for it. I think the first call out is as part of this platform workers bill, or the rolling out this piece of legislation, would be for the platform worker associations to be formed. So when the associations are set up, I hope all of you who are platform workers be part of the association, so that you can enjoy some of the things that I've shared earlier.
Okay, so for our participants, please keep your questions coming. So next, we are going to look at enhanced family-friendly benefits. It's an exciting time, right? I mean, I think both of you
Absolutely.
said that, we're trying to make more babies, we want to be pro-family, and balancing work and family has always been a big responsibility, whether it's children or you're a caregiver. Now employees are seeking more support actually from the workplace. So all these things that are coming in are just like jigsaw pieces. They're all sort of falling into place. So Amajit, could you just walk us through the recent updates to the family leave entitlements? I know dads now can have more leave.
Oh yes, I feel bad. I had my kids 18 years ago. No paternity leave. But I think this is again definitely a step in the right direction, complementary to all the other initiatives, right? Because it reckons with the reality that a person is a full person. You may be at work, but you still have a family. So how do you reconcile everything? And we don't live in very large families anymore, where people sort of you have grandparents, you have aunties, uncles who raise kids. So this is very important, right? Jan 2024, government paid paternity leave doubled from 2 to 4 weeks on a voluntary basis, right? Unpaid infant care leave doubled from 6 to 12 days per parent per year in the child's first 2 years. Unpaid, but still something that gives them the opportunity to take the leave if they need it when the child is young and requires the care. National Day rally, some very positive announcements. Shared parental leave increased from 4 weeks to 6 weeks from 1st April 2025, going up to 10 weeks from 1st April 2026, which is wonderful. Government paid paternity leave, existing scheme of mandatory 2 weeks plus the voluntary 2 weeks, subject to the employer's agreement, will evolve such that voluntary 2 weeks also become mandatory. So it's going to be 4 weeks of paternity leave. So with effect from 1st April 2025, eligible working fathers will receive this mandatory 4 weeks of paternity leave, which is wonderful. I think this is this should hopefully encourage people to have more children.
Yeah, I hope so. and PM has just announced yesterday that besides all these that you'll enjoy next year, there's also an SG60 gift if you're SG60 babies.
Oh yes, I saw that the bonus, right?
Yeah.
I don't know what it is, right? It was
Seriously, I'm looking forward to see what's
yes,
over and above all these whole slew of benefits.
Okay.
that's right.
So Patrick, a question, what are the strategies can NTUC suggest encouraging family-friendly workplace culture? Is there any tips that you want to share
I
with
think
us?
the a good starting point will be the flexible work arrangements. I thought that's important. And of course, we leave the companies to come up with creative ways to make their workforce more inclusive, and of course enhance female labor workforce, our female workforce participation rate. Because really, in Singapore, I'm getting a bit worried because if you look at employment, local workforce growth, it's kind of like stagnating, and it's kind of like flat out. So therefore, even with the increase in the retirement and re-employment ages, at the same time, yeah, we have improved quite a bit. Frankly, if you look at the stats in the last decade, we've caught up quite a bit with some of the Scandinavian countries, but still some way to go. Both for the aging, the older workers, as well as at the same time older for the female workers. Fully understand the challenges because of caregiving arrangements. Now, not just children, but our parents, our grandparents, who are living much longer today as compared to previously. So I totally understand that. But so now we important for employers to identify ways to maximize their workforce in the sense of ensuring they're engaged, ensuring there's flexibility to ensure that there's productivity at the same time. So so now employers have a bigger task. Not just just looking at bottom line profitability, but also seeing how to make sure you have a engaged workforce that is productive at the same time, flexible enough to allow you to maximize each and everyone to their full potential.
Anything to add, Amajit, on this?
I think Patrick summed it up very well.
Okay. Upskilling, right? So we talk about a jigsaw puzzle. So we have the flexible work arrangements, we've got the legislation and everything coming into place. Now let's look at the next step, right? Let's upskill our workforce. Patrick, because I need to ask you.
Yes. I love this space.
How is NTUC supporting companies and workers in their upskilling efforts? Because we're very big on competencies, we're very big on skills.
That's right.
Maybe want to share a little bit more, then I'll ask you about the resources.
Yeah, I thought two major areas that we've seen breakthrough this year. In fact, just yesterday, NTUC and the Labour Movement announced our reaching a mark of impacting more than 100,000 workers and having more than 2,500 company training committees. I think this training agenda is very, very big. I think we are fortunate because quite a number of years, even prior to COVID, we started the industry transformation journey and started to look at, basically smart factories, industry 4.0's, training, skills upgrading, skills future, individual initiated training, employer supported training. The whole spectrum of training. And I must say, having interacted with many of the labor unions across the globe, so as tripartite partners across the globe, that we are in a fortunate position. I think even as I engaged many, recently, in fact, I was at this global union gathering. Many of the countries, some of the unions have to lobby the governments to give more training funds to train workers as well as to provide support for training. We are in a fortunate position. We have the resources and we have a war chest of resources to help continuing education and training, not just mainstream, not just preschool, but all the way till post-retirement. You can still go for training at the individual level and employer supported level. So I think we are in a fortunate position. I think this will continue to be an important agenda. But there are a few big pieces that are coming up: generative artificial intelligence, sustainability, and what's happening. In fact, this is a big agenda across the globe through the International Labour Organization. They are also really propounding on focusing on upskilling and training of the workforce. So I think very, very important because skills obsolescence, job obsolescence happening at a rapid rate. Therefore, we really need to reskill, upskill, multi-skill, name it, to really stay on top of the curve and ahead of the curve as well. And not just that. So individually, as I shared earlier, NTUC the Labour Movement is partnering many companies. So if your company wants to tap on some of these company training grants, feel free to touch base with us. We use this abbreviation, CTC, where we really want to support companies in this training journey and including automation and transformation as well, and digitalization. So that's the training bit of it. But the other part of it, we are a bit concerned, and I'm glad I've been lobbying this for almost a decade. What we are seeing is this new job seeker support scheme. Yeah, I know Amajit had some slides on it, but I thought still a bit of thunder and share with you all this job seeker support scheme. I thought important to state the title of this scheme. It's called Skills Future Job Seeker Support Scheme. Very important. Why this title is important? It will kick off in April next year, 1st April next year. But the operative word is a support scheme. So it's not a unemployment benefit scheme. It's
Yeah.
not unemployment insurance scheme. Why is it important? Because when you talk about unemployment insurance, there's always contribution from the employee, the employer, and maybe some subvention from the government, like some countries do, including some of our Scandinavian countries have that. So it's not an insurance scheme. You don't have to fork out anything, because usually you have a very perverse situation where usually those people who are more vulnerable and in more riskier jobs that are likely to be laid off will tend to be on the scheme. So those people who are in more secure, more stable jobs will not be part of the scheme. So you have a much lower denominator. That's why I think we did not go to the unemployment insurance path. At the same time, it's not an unemployment benefit, because like some welfare states, the one of the banes of it is that there's a crutch mentality, and there's a disincentive to work.
Yes.
So therefore, we have abandoned both. We have gone for a support scheme. But what's interesting about this upcoming mid-career, or I wouldn't say mid-career, but job seeker support scheme, which is applicable to everyone, of course, with some salary limits up to $5,000, because this is the first attempt at it. I brought this up in Parliament, and Minister replied that they'll review it as we go along. But for a start, it's for those who are with income of less than 5,000 last drawn income, and they're giving some concessions lah. So even though, let's say you're affected now, you may still appeal to be part of the scheme. What's the most important and actually quite good of this scheme is that it's built in with two things. Firstly, is active labor market policy, meaning you don't get the money just like that. You actually have to show that you are actively looking for the next job. Yeah, either go for training, go for career counseling, go to see the employability coach at E2I, or if we provide some interviews for you, you have to attend the interview. Usually you must you must display some proactiveness. So that's active labor market policy. That's what's been happening in some countries, such as in the UK as well, where they introduce this to provide incentive to work. But the other thing that's most important, because the amount is by some standards maybe quite low. They said 6,000 for 6 months. Maybe not a lot. Of course, it's sort of it's a support scheme. It's a very first attempt. But more importantly, this job seeker support scheme is over and above all the other existing schemes. Meaning, if you are receiving some community help, or you are going for the Skills Future Level Up program, where there's actually a training allowance. The details are not out yet, but it's to be fleshed out in coming months. So this can actually be over and above. So someone who loses his or her job involuntarily, you cannot voluntarily resign and then get this benefit. So it has to be involuntary. And then you go for the training schemes, you can actually benefit and help you to tide through the difficult period before you pick up the relevant skills and land the next job.
Amajit, anything to add?
I just want to say Patrick never steals my thunder. Patrick is the man to be telling you about all of this, because Patrick knows what goes on behind the scenes. And I think that really sort of shines through. So really, I have nothing to add, except that, again, I think this is a very carefully calibrated move, which is absolutely critical, because our founding principles are we do not provide, it's not a welfare state. And we are not going to provide safety nets. So people should still be incentivized to do the best to try and find employment. And this is just an interim measure to help them tide over.
Yes, that's right.
I think that's absolutely critical.
And I'm a big fan of the Skills Future. I mean, we all have credits, right? And I'm going to tell everyone who's watching us, you all of us got credits. Please use that to your benefit. I've done so many picked up classes just with the Skills Future credits. Patrick,
no, I totally agree with you. But there are still quite a lot of you out there. And then if you are above 40, you get an additional $4,000 just in case you didn't know or didn't realize.
Yeah, I get that too.
I didn't say anything. But more importantly, I know there were some angry people who said, no, I'm not 40, I'm only 38, I don't get it. I said, okay, wait 2 years time, you get it. Yeah, so everybody will get it if you hit 40. And of course, this is over and above the existing tranche that we all received. All of us 25 above, we received $500, and there was a subsequent top up another $500. And for those not so young, there was actually another additional $500. So if you have not used anything at all, technically, if you go to your My Careers Future portal, or even your SingPass app. You just do a tap onto your SingPass app to the Skills Future or My Careers Future portal. You'll see how much Skills Future that you have. Even the Live SG app, I'm just testing it because now you get some vouchers apparently. Not yet downloaded, but it even tells you how much Skills Future credits you have. So in case you're not aware, just tap the app, and then you'll be able to know how much you have and what courses and programs you can actually go through. So it's a whole plethora of programs, you know. Yeah, sometimes
It's quite exhaustive, eh? It's amazing.
I get worried. You know, it's so exhaustive that when I was trying to scan to look for the right course, it's quite a insurmountable task because you are spoiled for choice. Yeah.
So I have a question actually from one of our viewers. I think he or she is under 30, fully utilized it, which is great. Will there be a top up? You have your ear on the ground and
Yeah, I always lobby for top ups. But in case you realize you're really so I congratulate you if you have already fully utilized. You're one of those that really proactively look at your individual initiative training. So in case pending the next top up by government, my suggestion to you is join as a NTUC member, because we actually provide a Union Training Assistance Program, UTAP for short. That provides you a top up of $250 if you're below 40. In this case, if you're above 40, it's $500 every year, as long as you're a member. So there's $250. There's of course the approved programs, and most of the programs are approved. And you can actually tap on this $250 indefinitely, meaning every year you you restart again on 1st Jan. So you can go for a program in December and then you get a restart in January. So it's a $250 every year, but it doesn't accumulate, so you don't get.
there's no rollover.
Yeah, there's no rollover. Sorry, but these are examples where you can actually maximize in pending any future top ups.
Okay. So I want to thank both of you for your insights. We've got some questions. We're going to toggle back to the FWA. There's a question now. The question is actually, will FWA encourage employers to hire foreigners because the job can be performed remotely or anywhere? I'm assuming this might be an employer asking.
Okay, so that's a very good question. I think that's something a lot of employers consider, grapple with, and some are already doing that, right? Some already have, back offices elsewhere, etc. I don't think the FWA will push them towards hiring more foreigners, because the foreigners who are working overseas and living overseas, I'm guessing, right?
Yes.
Not in Singapore. Because those guys are like fully flexible. So why don't they just offer their existing workforce flexibility? Do you know what I mean? There's a business case. Offer your existing guys who know your system, know your culture, the flexibility without having to say, it's not all or nothing. It's not we go for fully flexible workers in other countries that cost us less. It's about using your workforce and optimizing your own workforce rather than saying, you know what, this is too much hassle. I'm just going to hire people overseas. I don't think it should be a deterrent.
Patrick, anything to add on?
I said it's really very situational. It looks at the needs and the workings of the company or the business, and we can really fully flex it to maximize the productivity and maximize the participation. But sometimes you need certain expertise, for example, and the expertise may well be a freelancer, or it could be someone who may have caregiving arrangements or anything. I think it's going to be a needs basis and how far you can stretch yourself. So this provides an avenue for you to pick the right talent and the right people. And likewise, as we can tap on services overseas, I think it's happening since a long time ago, like outsourcing, offshoring. It's the other way around. Our local workforce can also provide services and provide and earn their keeps from corporations who are operating outside of Singapore and want to get hire Singapore talent because they want to come to Asia Pacific, they want to come to Asia. I think a lot of our local workforce are very adept and able to to operate. And we have a good reputation of good quality education, good quality work ethics, and of course a good quality workforce. I think that's as we are always top the few rankings globally, and I think this also provide opportunities for us to provide flex services, across the globe as well.
Okay. I have a question now. I think both of you highlighted is 25 employees and for FWA to be implemented.
Or WFL,
WFL.
WFL.
Okay, WFL.
Yeah.
So what if there are companies with limited resources, like for example, the charity sector, you got your small SMEs, or your startups who have very, very limited resources. Any suggestions on how they can sort of implement this moving forward?
So I think this takes us back to something Patrick said, which is that they're lobbying to have more readily available free resources, ideally templates, right?
Mm.
So that the barriers to adoption are not so high. They can just go to a website. This is a template that's put together by the tripartite partners in most cases, actually, which they can just adopt with some modifications. I think that would ease adoption amongst the smaller, as you say, micro SMEs, startups that may not have the resources to go to a law firm, for example, to have policies drafted. I mean, we do a lot of drafting for the MNCs, but they have very much larger budgets.
Yeah.
So I think in order for this to become something that's more widely adopted, even before the 5-year revisitation of this, it's to have the templates.
Yeah. In fact, as I alluded to earlier, the tripartite guidelines for the fair and progressive workplaces, I mean, has already been enforced for the longest. And if you have not gotten into trouble, likely you wouldn't get into trouble even with this new piece of legislation. So I think just, I mean, touch your heart, ensure that you have the right practices in place and be fair. I think then you would have actually very little pain and will not lose sleep over it.
Yeah. So
And I think there are trainings also. There are trainings
Yes.
that are being done. So to the extent possible, Jafet, for example, does some trainings, right, on various topics. Send your guys along for these trainings if they're free, just so your workforce is more informed.
Yeah, as a short advert also, we hope possibly to do a Law Works legal primer next year, to give you more details and provide you some practical handles. And I'm sure there are a lot of tripartite platforms, including so that's why when the act hopefully eventually passed by Jan next year, then you'll see a whole journey of evangelistic outreach and sharing, and with all the resources that you see in the flexible work arrangements, I think you should receive the same for WFL.
Okay, so I have WFA question. Let's say if my employer has approved me for flexible work and I'm working from home, and this is something that's really bugged me. I want to really ask both of you. Can I claim for my living needs because I'm working from home? Technically, my house is now an office. So can I claim for the electricity? Can I claim for water? Can I put in a request? As an employee, can I put that request to my employer?
Maybe before Amajit replies, I just wanted to say something. I mean, I raised this as a point because during the work from home and during the circuit breaker and the pandemic, when a lot of us are working from home, I asked this question of MOM, in fact, in Parliament. I say, well, what if I get injured in the course of carrying my stack, my laptop lands on my toes and then it cracks or fractures, and you'd be surprised. There was a reply from SMS Zaki to my question in Parliament. So his reply is there are actually cases where they have granted or given WICA claims for those working from home. So that's one area which to reassure everyone that yes, WICA claims will apply. Yeah, and of course, Regada's question is on all other expenses. So maybe
Amajit, how?
I would say consult your tax advisor to see what you can actually claim, because I think quite a bit may be.
Because the last I heard during the as part of the tripartite discussions during the work from home circuit breaker and everything else, one key thing was that they were asking about claims. Now that my air condition bill, energy bill has gone up, everything has gone up at home. Of course, there'll be savings in transport, but I think some of the allowable claims would be you probably need to show proof that because of you working from home, your energy bills have gone up. So you need to probably show some proof of some differential. I don't know how big the differential is, but you probably need to show like before and after, so that to justify your claims and claim it as employment expenses under your tax returns.
Okay, thank you. This is for a question on WFL actually. Someone's management keeps giving him or her empty promises on promotion, but giving reason that you're not up to it. And if you want your promotion, you need to work harder. Does this constitute harassment? Amajit.
Sadly, harassment is generally things that cause you alarm or distress. The person may be distressed, but I'm not sure if
Yes.
severe enough to qualify as harassment. But I can imagine how disappointed they feel. But probably hard to hang it on the head of harassment.
Any suggestions? Maybe they should go and speak to someone, maybe the HR person.
I think in the labor movement, we also encounter quite a bit of similar grievances where they feel, why are they passed for a promotion? Why, the boss always praises them, but they end up getting a less than desired grading for the year. And well, some of these things may be at the discretion of the employers. However, I like I said, in Singapore, we try to resolve things at the lowest level. So see your immediate supervisors, speak to your HR, instead of going for full throttle and sledgehammer, really go and try to resolve it at the lowest level so that and the proper channels. I know different companies have different grievance procedures and different processes. So go with those processes to get an audience to share your issue at hand. I thought that's the most important, being open and frank about it. And a word of advice to employers out there and HR practitioners out there, I think listen to your employees. Provide a listening ear. I think the key thing is to be open and transparent, to hear them out. And of course, to better explain them. Most of the time I realize in workplaces, the disputes, oftentimes I would say it's because of communication and miscommunication. Why am I underpaid? But actually, when it goes to, it's escalated, and then, you look at all the claims and you're like, oh, I forgot to add an additional line to say that actually this was this. And then my calculation included this, but I didn't show you the calculation, the formula. And why did I consider this because of this? So ended up, I realized most of the disputes come up because of miscommunication. So I thought employers and HR practitioners out there should take a leaf from this, that see it from the lens of the employee or the worker. What he or she, sometimes you may be carrying out a retrenchment, for example, and then you send him a check, but what is in that? What's covered, what's not covered? So that then there's a miscommunication, then because the employee will say, oh, like that only, means you forgot to pay me this, that, and stuff like that. Maybe leave owing, notice period, etc. So I thought good to itemize and be more transparent, be more open, and so that to minimize any miscommunication, because that's where all the disputes come up.
Very good point. I have one piece of advice for the employee. So when faced with this sort of situation, right, you can go and see HR. You should definitely see HR. Don't escalate the investigation. Speak to others around you, allies within the firm, people who you look up to, advisors. But before you do that, put together, if you say you're doing a good job, that you're being passed over, put together evidence of, success stories, compliments, feedback, positive feedback. Do yourself a favor by compiling some evidence to show that actually you're doing a good job, you're suited for the role, you have compatible skills. It helps the conversation rather than saying, you know what, I feel like I've been looked over and it's overlooked for this and it's not fair. And I think it helps to couch it in more objective terms with evidence where it's available.
Okay, so I think I have another question. Okay. Again, I think someone's asking for legal advice, but let's give it a stab, okay? A staff has shown signs of hostility and mentioned that she was having mental health distress. I'm assuming this is the employer. Despite communication and counseling services, they have advised her to take some time off. The staff now thinks that she's being asked to leave. So what can the employer, what are the steps maybe not so much advice, but any steps the employer can take to sort of ring fence or, I'm not sure how.
Okay, so not giving legal advice,
No.
but I think these sorts of situations arise, again, communication, right? Because the employer may be saying, take some time off, look after your health, recover, get better, and then come back to work. But the employee who's naturally feeling vulnerable already because of the mental health issues may interpret that as, okay, I'm being shown the door. Being told to stay home is an inevitable path to termination. That may not be the case. So again, the employer should take pains to say, actually, we are not terminating you. This is for your health and well-being. We are giving you some time off to recover, seek medical help, seek the support you need. Now, if they are going to terminate, that's another story, okay? This is on the assumption that they're not terminating and this is just for the employee's health and well-being. If they are going to terminate, then there are other things they should do, which would be veering into legal advice.
Okay. Another question of FWL. Does it apply to toxic and unreasonable termination?
Yeah. So if I may answer this, I mean, barring the act will be fleshed out hopefully by next week. The key thing is discrimination. I mean, Amajit gave the working definition of it. So if it leads to then dismissal or term ending of employment, then it will be covered within the WFL piece. So for more details, wait for the WFL piece. But otherwise, if there's a wrongful termination, there's already existing legislation through the Employment Act, as well as through a civil claim, or if you are in a unionized environment or union member, then through our Industrial Relations Act and our usual conciliation and wrongful dismissal provisions. So this is there will be recourse in both ways.
Okay. I think this is a good question actually. When should someone approach TADM versus Employment Claims Tribunal versus MOM?
Okay, maybe I'll take that.
Okay.
Yeah. Let's talk about a unionized environment. If you're a union member in a unionized company, if you do come to the union to file a grievance, and if there's and we need to resolve the grievance, and before escalating it further, usually we refer the next, if you can't come to some, negotiated deal or settlement, we usually will escalate it for conciliation of the Ministry of Manpower. So that's where the Ministry of Manpower comes in. And after Ministry of Manpower, there's a deadlock, there's still the Industrial Arbitration Court and of course industrial action. So this is the unionized route of dispute resolution. But that's where through MOM and of course other issues as well. But for TADM and Employment Claims Tribunal, Employment Claims Tribunal is on what I shared was under the Industrial Relations Act. For the Employment Claims Tribunal is governed by Employment Claims Act, a separate piece of legislation. Anyone that comes and it covers mostly the statutory claims in the Employment Act as well as now wrongful dismissal as well. And but the first port of call is usually TADM. And TADM is a tripartite, stands for Tripartite Alliance for Disputes Management. It's actually a tripartite mechanism that the tripartite partners, i.e. Ministry of Manpower, National Trades Union Congress, as well as our Singapore National Employers Federation. We kind of like co-created the Tripartite Alliance and Tripartite Alliance for Dispute Management. So actually it's a mechanism to try to resolve things at the lowest level. So usually all claims that may be routed to ECT, the first port of call will be TADM, and then TADM will do a triage. So if you are in a unionized, if they discover in a triage that you are a union member in a unionized company, they usually will refer to the unions to assist you in that dispute resolution process. However, if you're not a union member, you're not in a unionized company, then they will take your claims and then hear you out. But of course, the first port of call is always hearing parties, and of course to see whether, and also to advise you whether there's a case before it actually goes up even to Employment Claims Tribunal. Separately, there's also something called a tripartite mediation panel. That's also availed to union members who take the TADM route instead of the traditional route, because there are some members that may be outside, maybe union members, but maybe not within the auspices of a particular union's scope, and therefore they can actually go through a tripartite mediation panel. And the good thing about going through a tripartite mediation panel is that your claims limit is expanded from 20,000 to 30,000. And therefore, this is a long answer to the difference between Ministry of Manpower, TADM, and Employment Claims Act, Employment Claims Tribunal. But take note The Employment Claims Tribunal is powered by the state courts. So it's by the judiciary. Whereas TADM, like I said, is a tripartite body. And of course, Ministry of Manpower is government. So to be aware of where you're going to get things resolved and how things are being resolved.
Okay, thank you. Manjit, anything to add before we round this up?
Yes, I have lots of people who say, can we just go straight to MOM? And I think going back to Patrick's answer, be very clear on what it is you want and what are the correct avenues to follow.
Yeah.
Don't just go straight running to MOM.
The good news is that there are a lot of resources online. I love the MOM website. I love my NTUC website too. So everything's available there, and we even have a pocket series as part of our Works partnership as well. So there are actually a lot of resources online. So just search for it. Now you can even use ChatGPT and
To
Copilot.
summarize it, yes.
But please do your due diligence, fact check, and check for accuracy. And of course, you can consult and call the hotlines to find out if you are knocking on the right door.
Okay, so thank you both. As we wrap up this webinar, I want to invite each one of you for one key takeaway for our viewers, something that you want them to walk away with that you'll remember. Yeah. Shall I start with Amajit first?
Sure. I think we're in exciting times. We're in changing times. So everyone should keep an open mind and be aware of their rights, whether they are employees. Employers should be aware of their obligations. And I think we should really be very pleased in the direction this is heading in, which is towards protecting employees more, but also being very mindful, being Singapore, that, employers and companies are also critical to our economy and to our survival.
Patrick.
Yeah, I mean, our topic today is on navigating the employment landscape. So, what better way to end to say that, the landscape is really changing rapidly. And there are a lot of developments. So to stay abreast, I think very, very important to stay abreast of some of these developments. I know some of you tuning in could be workers, could be freelancers, platform workers as well, could be HR practitioners, could be business owners, companies, employers, or even in-house counsel and lawyers. So I think the key thing, whether you're in any particular segment, is to really stay abreast of some of the developments, so that as you do your work, or if you get in trouble, or face some of these issues in the workplace, you know where to go to, you know where to check for resources. At the same time, also know the right way of approaching some of these issues and challenges that you face.
Well, thank you. And this actually brings us to the end of the last webinar for Law Awareness Weeks at CDC 2024.
Wow.
Now, for those of you who have followed all our webinars, thank you. And we hope that you have leveled up on your legal literacy over the past 13 webinars. So do look out for us when we return Law Awareness Weeks in 2025. You can visit go.gov.sg/LAW-CDC. Now, for other events by Pro Bono SG, do check out the event page on Pro Bono SG website or LawGoWare. Okay, I'm saying it in that slang. The links will be dropped in the chat function. Now, if you found today's webinar to be beneficial and you want to share it with your employer or your employees, family and friends, the recording of this webinar will be made available on Pro Bono SG's YouTube channel in 2 weeks' time. The link to the channel will be dropped into the chat. Now, before we want to let you go, a survey form will pop up on your screen for your completion. We appreciate your comments so we can improve it further. And while you're filling out that survey, thank you very much for a fantastic sharing. And really, thank you, Amajit, and for closing the last webinar for Law Awareness Weeks. It really has highlighted the importance of staying agile, the importance of adaptability, because the landscape is evolving. We are also learning at the same time. From new guidelines on flexible work to legal protection in the gig economy, it is clear that balancing the needs of employees and employers is key to building a sustainable and safe workplace. And I think that is so important.
Agreed.
Right? So as we adapt to these changes, stay compliant, foster a positive work environment, is so crucial for your success. So once again, Amajit and Patrick, I cannot thank you enough. And to everyone who joined us today, we hope you feel more empowered and you can navigate much easily the evolving landscape. And, we have shared all the resources for you. On behalf of Pro Bono SG, thank you very much for joining us today and have a good week ahead. Thank you.
Thanks.
Thank you.